Welcome to this explainer. Today, we're unpacking what is, honestly, a fascinating, high-stakes legal thriller that ultimately made its way to the highest court in South Africa. We're talking about an incredible story here, one that involves ancient indigenous law, colonial annexation, and a very lucrative diamond-rich strip of land. It's a case that asks some really profound questions about who truly owns the earth beneath our feet and exactly how history gets judged in a modern courtroom.
Okay, let's dive into this. We've got a clear, step-by-step roadmap for making sense of over 150 years of complex constitutional history without getting lost. We'll start with the Richtersveld land claim, explore indigenous law and ownership, look at the impact of annexation, get into diamonds and dispossession, evaluate redressing discriminatory laws, and finally, look at the landmark ruling.
Section 1. The Richtersveld Land Claim, The Quest for Restitution.
So our scene is set in the vast, remote northwestern corner of South Africa's Northern Cape province. But this claim isn't actually about the entire territory. The Richtersveld Community is specifically claiming a narrow, diamond-rich coastal strip of land that runs from the Gariep River down to just below Port Nolloth. At the time of this case, this strip was registered to the state-owned diamond mining company Alexkor. And to really grasp the sheer scale of the history we're covering, just look at this timeline. We have to begin way back in 1847 with the British annexation of the Cape. Then we jump forward to 1913, which is the date of the Natives' Land Act. Moving into the 1920s, we hit the discovery of diamonds, which, as you'll see, literally changes everything. And finally, 1998 marks the absolute cutoff deadline for communities to lodge these modern restitution claims. It's a massive, massive historical sweep.
Now, the legal foundation of this entire case rests on the Restitution of Land Rights Act. Let's break down this absolutely crucial legal definition. Restitution basically means the restoration of a right in land, or equitable redress, for a community that was dispossessed specifically after June 19, 1913, as a result of past racially discriminatory laws. So the huge hurdle the community faced right out of the gate was proving not just that they originally owned the land, but that their dispossession happened after that very specific 1913 date. Section 2. Indigenous Law and Ownership. Before the Crown. To figure out if they were actually dispossessed after 1913, the Constitutional Court first had to rewind the clock and determine what rights the community held way back before the British even arrived in 1847. It's really fascinating how they did this. The judges recognized that they had to understand the community's rights through the community's own unwritten legal system. Indigenous law is an independent system of norms and values. It's passed from generation to generation, and it naturally evolves with the community. Crucially, the court noted that we cannot judge these rights by looking through the prism of European common law. They are distinct, original, and entirely valid on their own terms. And this brilliantly illustrates the danger of viewing indigenous rights through that common law prism. A powerful Privy Council ruling highlighted the risk, stating, "There is a tendency, operating at times unconsciously, to render that title conceptually in terms which are appropriate only to systems which have grown up under English law. But this tendency has to be held in check closely." Basically, you simply cannot evaluate an adaptive, communal indigenous system using the rigid, paper-based rules of English property law. It's like trying to force a square peg into a round hole. So what did this indigenous ownership actually look like in practice? Well, the land was communally owned. Access for outsiders was strictly regulated. For example, in 1847, a trader named McDougall actually had to get permission from the community and pay a fee just to set up camp at the river mouth. They also issued fines for unauthorized grazing. And most incredibly, especially given the modern diamond dispute, there was a long, deeply documented history of them mining and smelting copper and iron for ornaments. I mean, they even granted official mineral leases to outsiders between 1856 and 1910. All of this specific historical detail unequivocally proves that under indigenous law, the community owned the land and its minerals long before Europeans arrived. Section 3. The Impact of Annexation, 1847 and beyond. Now we hit our first major complication in this historical thriller, the British Crown officially annexing the Cape Colony, which incorporated the Richtersveld. And this forces us to ask the exact same legal puzzle the Constitutional Court judges had to solve. Did the 1847 British annexation automatically extinguish the Richtersveld community's rights to their land? Did the simple act of drawing a new political border on a map magically erase centuries of indigenous ownership? The answer to that is a resounding no. Referencing this quote from the Privy Council, the court firmly established that
The courts will assume that the British Crown intends that the rights of property of the inhabitants are to be fully respected. A mere change in political sovereignty simply does not erase the existing private or communal property rights of the people who are already living there. In fact, subsequent colonial laws completely backed this up. The Crown Lands Acts of 1860 and 1887 explicitly respected land that was being occupied beneficially, even without written title deeds. They created mechanisms to adjudicate these claims rather than just tossing them out. So, because no colonial law or official act of state had extinguished their rights before 1913, the court found that the Richtersveld community's indigenous ownership remained fully, legally intact as the 20th century dawned.
Section 4. Diamonds and Dispossession. The 1920s turning point.
But then, everything changed. We arrive at a devastating turning point in the 1920s when a massive, game-changing discovery of diamonds shifted the fate of the Richtersveld community forever. Now, what's really interesting about this slide is how perfectly it contrasts these two completely different systems of proving ownership. On one side, you have common law ownership, which relies heavily on individual, formal registration in a deeds office with written title deeds. On the other side, indigenous law ownership is communal, it's unwritten, it's adaptive, and it's passed down without any formal paper registration. This fundamental clash is exactly what set the stage for the community's rights to be entirely ignored.
Following the Diamond Rush, the state rolled out the Precious Stones Act of 1927. This new law completely ignored unregistered indigenous rights. It treated the Richtersveld simply as unalienated crown land, basically because there was no paper deed sitting in a registry somewhere. This specific legal maneuver allowed the state to establish state-run alluvial diamond diggings right on top of the community's ancestral home, acting as if their ancient rights just didn't exist at all. As you can imagine, the real-world impact of the Precious Stones Act on the community was devastating. Their ancient recognized rights to occupy and exploit their land were totally ignored. Suddenly, just being present on their own ancestral land became a criminal offense. Even taking water from the digging areas was criminalized. The community was literally fenced off, physically excluded from their own home, and the land was eventually transferred straight to the state-owned company Alexkor. Section 5. Redressing Discriminatory Laws. The court's evaluation. Fast forward decades later, and the modern constitutional court had to evaluate these 1920s actions against the strict criteria laid out in the 1994 Restitution of Land Rights Act. They had to walk through an exact three-step legal checklist. Step 1, prove the community was actually dispossessed of a right in land. Step 2, prove the dispossession occurred after the threshold date of June 19, 1913. And Step 3, prove the dispossession was the direct result of past racially discriminatory laws or practices. Based on the 1920s Diamond Rush eviction we just covered, the court easily confirmed that Steps 1 and 2 were satisfied. The only real question left was Step 3.
So, was the Precious Stones Act racially discriminatory? Take a look at the stark juxtaposition here. Registered, overwhelmingly white owners were completely recognized and protected. They retained access, their homesteads were safe, and they even received mineral claims and half the license money. In sharp, undeniable contrast, indigenous black owners were entirely unrecognized. They were criminalized for occupying their own land, entirely excluded from all that mineral wealth, and forcibly restricted to reserves. The court found that by protecting only written deeds and completely ignoring indigenous law, the Precious Stones Act was inherently racially discriminatory. Step 3 was satisfied.
Section 6, the landmark ruling, restoring the rights.
So the crucial point is how the highest court in the land finalized this century-old grievance, and they did it in a unanimous, truly groundbreaking decision. The Constitutional Court declared that the Richtersveld community is absolutely entitled to the restitution of the right to ownership of the subject land. And crucially, this includes its minerals and precious stones, validated entirely under their own indigenous law. The community won back not just the surface land, but the immense mineral wealth beneath it, essentially proving that their unwritten laws were just as legally binding as any piece of paper.
It's an absolutely remarkable legal journey, right? I want to leave you with this final, provocative thought to ponder. If unwritten indigenous laws can legally outlast colonial empires and century-old mining laws, what other historic rights might still be hidden just beneath the surface of our modern legal systems? Thank you so much for joining me on this explainer. Keep learning, stay curious, and I'll see you next time.